Dr. Keith, who qualified in 2017 with an MBBS from Queen Mary University, was undergoing his Foundation Year 2 training at Grantham Hospital, which is part of the United Lincolnshire Hospitals NHS Trust. Allegations were made that he rented a room in Nottingham and received assistance from ULHT for accommodation during his placement in Grantham. However, it was alleged that he terminated his tenancy agreement for the Nottingham property on September 1, 2018, and moved in with a relative without a tenancy agreement in place. Dr. Keith did not update ULHT with the change in his living arrangements, continued to use the provided accommodation until July 31, 2019, and requested an extension to his stay. It was claimed that Dr. Keith knew that he was only entitled to the accommodation rent-free if he was paying rent for accommodation elsewhere and that his actions were dishonest. ULHT initially raised concerns, and the GMC was informed after an investigation by a local counter-fraud specialist. The allegation made against Dr. Keith was that, as a registered medical practitioner, he completed an application form for assistance with accommodation, travel assistance for doctors in training for the ULHT on July 21, 2018. He stated that his tenancy at the address provided would expire on August 7, 2019, and signed that he would inform the trust immediately of any changes in rental arrangements. However, he failed to inform the trust that his tenancy expired on September 1, 2018, and continued to stay at the provided accommodation, rent-free, until July 31, 2019. On July 1, 2019, he requested an extension to his stay at the Grantham property without advising the trust that he was no longer paying rent for accommodation elsewhere. It was alleged that he knew he was only entitled to stay at the property rent-free if he was paying rental costs for accommodation elsewhere at the same time. The allegation also stated that his conduct was dishonest due to this reason, and his fitness to practice was impaired because of his misconduct. The tribunal is required to determine whether Dr. Keith asked the trust to extend his stay at the Grantham property and failed to advise them that he no longer paid rent elsewhere. It must also determine whether Dr. Keith knew that he was only entitled to stay at the Grantham property rent-free if he was paying rent elsewhere at the same time and whether his actions were therefore dishonest. Dr. Keith provided his own witness statement and gave oral evidence at the hearing, and the tribunal received evidence on his behalf in the form of a witness statement from Dr. A specialist in emergency medicine at Grantham Hospital, dated June 20, 2022. However, Dr. A was not called to give oral evidence due to technical and availability issues, and this was agreed by the parties and panel. The tribunal considered various documentary evidence provided by the parties, including Dr. Keith's application form for accommodation assistance at ULHT, his tenancy agreement for a property in Nottingham, email correspondence regarding a request for accommodation with ULHT, Dr. Keith's bank statements from May to December 2018, documents from the local counter-fraud specialist at ULHT, an invoice for recovery of accommodation costs, and a letter from ULHT to Dr. Keith confirming no intention to seek prosecution and a referral to the GMC. The Medical Practitioners Tribunal analyzed each allegation against Dr. Keith separately and evaluated the evidence presented during the hearing. Some allegations were admitted by Dr. Keith and were found to be proven. The tribunal found that there was not enough evidence to suggest that Dr. Keith had submitted an application for an extension to stay at the Grantham property. The tribunal found that Dr. Keith had engaged with the application form and had read the warnings but still submitted an incorrect date. Thus, this allegation was found to be proven. The tribunal has determined the facts as follows. Dr. Keith completed an application for assistance with accommodation, travel assistance for doctors in training for the United Lincolnshire Hospitals NHS Trust. He stated that his tenancy at the address would expire on August 7, 2019, and signed that he would inform the trust immediately of any change of rental arrangements. Dr. Keith failed to let the trust know that his tenancy expired on September 1, 2018, and continued to stay at the assisted living accommodation provided by the trust, rent-free, until July 31, 2019. He asked the trust to extend his stay at the Grantham property on July 1, 2019, without advising them that he no longer paid rent for accommodation elsewhere. Dr. Keith knew that he was only entitled to stay at the Grantham property rent-free if he paid rental costs for accommodation elsewhere at the same time. The tribunal found that his conduct was dishonest. The tribunal has taken into account all the evidence presented, including 12 testimonials from friends and colleagues, and documentary evidence confirming that Dr. Keith is booked onto a maintaining professional ethics course in near future. The counsel, on behalf of the GMC, argued that Dr. Keith's actions amounted to serious misconduct and that his fitness to practice is impaired. She drew the tribunal's attention to the principles of good medical practice that Dr. Keith had breached, namely you must make sure that your conduct justifies your patients' trust in you and the public's trust in the profession, you must be honest and trustworthy in all your communication with patients and colleagues, and you must be honest and trustworthy when writing reports. The counsel submitted that Dr. Keith had breached these principles by being dishonest and failing to provide accurate information regarding his accommodation to his employer. She also argued that Dr. Keith's actions were serious as they resulted in a financial benefit to him, in that he was provided with free accommodation with a value of approximately £6,300. The counsel reminded the tribunal of the statutory overarching objective and the importance of the public interest limbs of these objectives in maintaining public confidence in the medical profession and upholding and maintaining proper standards and conduct. She argued that the tribunal should consider the test as set out by Dame Janet Smith in her fifth report from the Shipman inquiry when determining impairment. The test is whether the findings of fact show that the doctor's fitness to practice is impaired in the sense that they have in the past acted and, or are liable in the future to act so as to put a patient or patients at unwarranted risk of harm, and, or have in the past brought and, or are liable in the future to bring the medical profession into disrepute, and, or have in the past breached and, or are liable in the future to breach one of the fundamental tenets of the medical profession, and or have in the past acted dishonestly and, or are liable to act dishonestly in the future. The counsel argued that Dr. Keith's actions fell under the categories of bringing the medical profession into disrepute and breaching one of the fundamental tenets of the medical profession. She also suggested that dishonesty is difficult to remediate, despite Dr. Keith having repaid some of the money to the trust and have booked onto an ethics course. The counsel drew the tribunal's attention to the case of Yeong v. GMC, which states that a finding of impairment of fitness to practice may be justified where the misconduct consists of violating a fundamental rule of the professional relationship between medical practitioner and patient and thereby undermining public confidence in the medical profession. The Medical Practitioners Tribunal found Dr. Keith guilty of serious misconduct for breaching principles set out in good medical practice, specifically in relation to dishonesty in financial and commercial dealings with his employer. The tribunal considered Dr. Keith's remorse and steps taken towards remediation, including repaying the trust and booking a professional ethics course. While there were no concerns about Dr. Keith's clinical skills or patient safety, the tribunal concluded that his actions had brought the medical profession into disrepute, breached fundamental tenets of the profession, and were dishonest, thus impairing his fitness to practice. On behalf of the GMC, the counsel submitted that the appropriate sanction was a period of suspension, citing the sanctions guidance and the case of Bolton v. the Law Society. She reminded the tribunal that Dr. Keith had breached several principles of good medical practice, which it had categorized as significant, and submitted that action was necessary. The counsel submitted that taking no action was not appropriate, as there were no exceptional circumstances. She drew the tribunal's attention to the relevant paragraphs of the sanctions guidance dealing with suspension, noting that it has a deterrent effect and sends a signal to the wider profession that a doctor's conduct is unacceptable. The counsel accepted that the dishonesty found proved was an isolated case and that Dr. Keith had acknowledged fault. She noted that the money was being repaid to the trust and that he had shown some insight and remediation. The counsel drew the tribunal's attention to paragraph 93 of the sanctions guidance, which states that suspension may be appropriate where there may have been acknowledgement of fault and where the behavior or incident is unlikely to be repeated. She also drew attention to examples in paragraph 97 of the sanctions guidance where suspension may be appropriate, including where there is no evidence that demonstrates remediation is unlikely to be successful and where the tribunal is satisfied the doctor has insight and does not pose a significant risk of repeating behavior. The counsel also drew attention to paragraphs 120 to 125 of the sanctions guidance, which deals specifically with dishonesty, and submitted that defrauding an employer was an example of dishonesty in professional practice. On behalf of defense, the counsel submitted that a period of suspension was the appropriate sanction and suggested a length of 3 months. He drew the tribunal's attention to testimonials highlighting Dr. Keith's honesty, integrity, clinical skills, competence, good nature, and character. The counsel pointed out several mitigating factors, including Dr. Keith's immediate cooperation with the investigation, his acceptance of the seriousness of his misconduct, his developing insight, and his lack of previous or subsequent dishonest behavior. The counsel also noted the lapse of time since the incident and Dr. Keith's difficult working conditions in a busy accident and emergency department. The only aggravating factor present was that this was a case of dishonesty. The counsel referred to examples in the sanctions guidance where a suspension may be appropriate and suggested that factors listed at paragraphs 97A, E, F, and G were relevant. He invited the tribunal to consider the guidance on erasure but submitted that none of the features indicating erasure were present in this case. The tribunal considered all the evidence and relevant legal principles in determining an appropriate sanction. It was advised to take the protection of the public and promotion of proper standards into account and to apply the principle of proportionality. The tribunal identified the aggravating factor of Dr. Keith's dishonesty and mitigating factors such as his remorse, repayment of the trust, and positive testimonials. It found that taking no action was not appropriate and that conditions were not sufficient to address the dishonesty issue. After considering submissions on suspension, the tribunal concluded that a 2-month suspension would properly mark Dr. Keith's conduct as unacceptable and send a signal to the profession and wider public. It found that a longer period of suspension or erasure was not applicable or proportionate to the misconduct found. The tribunal balanced the seriousness of the findings with the public interest in retaining access to good doctors and noted that Dr. Keith was unlikely to act in this way again. The tribunal did not find the need to direct a review and did not impose an immediate order. The GMC also did not seek an immediate order in this case.